Hello, everybody, and welcome to JCPC Watch, the podcast about the Judicial Committee of the Privy Council. I am your host, Mark Russell. I'm joined by Rupert Wheeler.
Hey, how you doing?
Well, I think everyone's doing okay. It's our second episode, Rupert.
It
And
is.
since we last got together, there's been a lot of judgments have come down. People got back from the summer and just started finishing up those drafts, I guess, and started pushing them out. So we'll have a lot to talk about. And
Absolutely. After the bit of the dry patch over the summer, we've got plenty now.
there's
To the extent it's hard to know which to choose,
it
really.
was it, wa-
But
it was difficult coming up with the kind of the two ones to do a deeper dive into, wasn't it? Even though we didn't have some kind of big, I think, headline cases from kind of the more prominent jurisdictions. I think we also got some interesting decisions from jurisdictions that you might not expect that have some more broader application as well.
absolutely,
So we'll
absolutely.
talk about those. Before we get into it, Rupert, what's been keeping you busy? What have you been up to lately?
Yeah, I've been good. Just easing into the English autumn, which is always nice. I was up in Manchester last week at the 23 ES conference, talking about directors' duties and knowing receipt, which was a fun afternoon. Um, And so, yeah, traveling around a bit and just, cracking the whip. So can't complain. How you been doing?
Yeah, pretty good, pretty good. Like you, quite busy as always kind of happens when the calendar turns over into September and into October. You
Yeah,
Everything picks up. A lot of contentious insolvency work. A few other little arbitration bits and bobs, kind of rumbling on. So, but yeah, it's been busy. It's been jam packed. There's a lot been going on, and I think the fall is going to be busy as well. So, but it's been a busy, as we said, it's been a busy month of the Privy Council as well. So, what we will do is round up some of those judgments that came out in September, and then we're going to take a bit of a deeper dive into two cases: Cable and Wireless Jamaica Ltd against Abrahams, and then Krys and Farnum Place LLC. So those are the two cases we're going to talk about first. But let's just have a quick rundown through what happened in September. And it was, I think, fair to say, heavy on Trinidad and Tobago cases in
yeah,
September,
yeah.
as the Privy Council tends to be. There's definitely we should go back and look at some of the stats, but Trinidad and Tobago cases certainly make up a big part of the workload.
No, they really
Mm,
do. They really
yeah,
do. Um, I'd say probably probably the jurisdiction that's appealed from the most. Um, I don't quite know why that is. Maybe there are more options to appeal to the Privy Council. It's the appeal of as of right is available more. I don't quite know
yeah,
the
I don't know.
exact
Maybe we'll have
statutory
to get
framework.
someone from Trinidad and Tobago have to come on the podcast sometime. We'll
Yeah.
talk about it. But the first one up was Trinidad and Tobago. It was the Public Services Association of Trinidad and Tobago against the Trinidad and Tobago Civil Aviation Authority. It was a dispute about whether the Public Services Association was, under some statutory provisions, deemed to be the recognized majority union for a bargaining unit of certain employees at the Aviation Authority. The Privy Council held that they were so deemed to be, but that the cross appeal regarding whether the Civil Aviation Authority had committed an offense by failing to collectively bargain with the union. They hadn't committed that offense because at the relevant time, the Public Services Association had not been formally registered as the union because they were still in the first dispute that the Privy Council had to settle. So that's been resolved. It really just turned on specific statutory provisions and the interpretation of some Trinidad and Tobago legislation. So nothing really a broader application there. We also had the and this was one from Trinidad that has some broader application. And I think we'll probably be talking about this one on a later podcast. Maybe bring on a liquidator to
Great
talk
idea.
about it as a special guest and how they think this case is going to impact them going forward. But it was Attorney General of Trinidad and Tobago against CL Financial Limited. It was about the approval of a court-appointed liquidator's fees. Ultimately, the board sent it back to the High Court for assessment of those fees on the correct principles. and they spent a lot of time in the board decision doing a deep dive into the law on liquidators and other insolvency office holders' remuneration and how the parties in the court should approach that assessment. So, if you're in the kind of liquidation, administrator, insolvency office holder space, it really is a must read because it kind of resets the law and restates the law as respects that issue as to how their costs should be assessed and your remuneration should be assessed.
Yeah. Yeah. No, it's interesting. And I agree. We should get a liquidator on, or someone who's working in that space on, to get their view, because it's one that's picked up quite a lot of commentary already. Um, I've seen various law firms and chambers do articles on it. So I think everyone recognizes that it is going to have a pretty wide effect. So perhaps one we should revisit, I think, in the near future.
Yeah, absolutely, absolutely. One that we won't be revisiting in the future is the University of the West Indies against the Occupational Safety and Health Authority and Agency, also from Trinidad and Tobago. This again, a Trinidad and Tobago statutory construction case. The board agreed with the Court of Appeal that the Occupational Health and Safety Act applied a 6-month time limit for the prosecution of any criminal offenses under the Act, whether they were brought before a magistrate or the industrial court. The thing that really stood out for me about this case was that the actual underlying health and safety offense was that a man got like run over by a sheep.
By sheep.
A sheep. Yeah.
Well, that does sound pretty unhealthy, to be fair.
The University of West Indies apparently needs to keep closer eye on their livestock.
Yeah.
We also had, again, Trinidad and Tobago, the chief fire officer against Ramsaran. This was a judicial appointment, a judicial review issue, where the board found that the appellant had been denied a fair opportunity to be considered for appointment as the deputy chief fire officer, and he was entitled to have his damages assessed by the High Court. Again, pretty straightforward judicial review principles here. Nothing earth shattering. It's Trinidad and Tobago cases just end up at the Privy Council.
Yeah, I do. I mean, I think it would be interesting to just look into a little bit more detail as to why there are so many
Mm.
appeals. Maybe I'll look that up for our next before our next
Yeah, that would be
episode.
great. Yeah, yeah. Just a few more to get to, but you know where this one's coming from. Trinidad and Tobago, Frotman and Ramsaroop. It was a costs case, and I have to say, as soon as a case has to do with cost principles, my eyes start to glaze over.
Yeah,
The specific issue was whether brief fees were recoverable. In this habeas corpus case. The board agreed here that they were not. It did discuss various cost assessments points that may be of interest to practitioners in that area. Everybody else, frankly, stay clear of this one.
yeah, yeah.
Um,
No, habeas corpus is quite an interesting area of
it
law.
didn't really come up
Not
in
one
the
we come
judgment.
across
I don't
too
know
much.
if you read that judgment.
Yeah, I think
It
that
doesn't
one
really
passed me
come
by,
up.
actually. Yeah,
It is costs heavy.
yeah,
Yeah. We also had a little shift now into some more kind of commercial cases that came out. Fong Hong Kong against Green Elite Limited came out of the British Virgin Islands. That was an interesting one about the duomatic principle. The courts below had found for the liquidator of Green Elite that the company's assets had been transferred to the appellants and others in breach of the director's fiduciary duties. The board agreed with that finding. It also agreed that the duomatic principle could not apply based on the factual findings because there had been no agreement between the shareholders concerning the particular transfers. The board also did make a little clarification, which I think is going to be important for people trying to apply the duomatic principle going forward, that shareholders don't need to have an agreement that reaches the level of a binding contract for the duomatic principle to apply, but they must intend to be bound as if they had passed a formal resolution. So I think you'll see that kind of end up being cited in the when you set out the list of what the duomatic principle is in future Skeldon arguments.
yeah,
And then finally, we have from the Cayman Islands, Meso Capital Investments Limited against Trina Solar Limited. This was again a merger appraisal case, and a lot of these. This seems to be what is coming up from the Cayman Islands courts a lot now to the Privy Council. Certainly this year, there's been a few of these already. This one was about how the judge determined fair value, At trial, and these are lengthy trials, they're heavily fact-based, and the judge is asked to make a lot of very heavy fact-based decision making and evaluative assessments when they're coming to their conclusions. The trial judge determined fair value by weighing various valuations that were offered up and that he had found as appropriate values on as market price, merger price, discounted price. He weighted the merger price, the previously agreed price, at 45%. On appeal to the Court of Appeal in the Cayman Islands, the court said that he was wrong to do so, to put any weight on the merger price, and they removed the merger price from the equation and recalculated what fair value was. At the Privy Council, the board restored the trial judge's decision, finding that it was an evaluative assessment in a highly fact specific context and that the trial judge was entitled to make that decision, whereas the Court of Appeal had gone too far in substituting its own analysis. So it's a really interesting case for people who practice in that area. I think more generally, we see a lot of these Privy Council decisions where they kind of tell the Court of Appeal, "You've gone too far." Not just from the Cayman Islands Court. We're not gonna pick on the Cayman Islands Court of
Yeah.
Appeal, but I think in general, we see a lot of these judgments where effectively what the board says is the Court of Appeal went beyond the scope of an appellate court in reviewing and substituting its own analysis, for what the trial judge had done or the judge of first instance.
Yeah, it's interesting, isn't it? A reminder of the restraint that should be exercised in the appellate jurisdiction, I suppose, and maybe one that is not so readily exercised in some of the some of these jurisdictions called courts of appeal. I think our own experience might say or might show that the Cayman Islands Court of Appeal can be fairly um, robust or creative when it comes to the restriction on its own
They
appellate
can be
restraint.
interventionist.
Yeah,
Yeah, absolutely. Look, I'm sure when you're an appellate judge, it is very tempting to just say, "Well, I just think the trial judge got it wrong, and I'm just gonna do this myself. I'm just gonna substitute my own decision." I'm sure
yeah,
that's very tempting. As you say, it's not the appropriate assessment on a lot of the things that do get appealed.
yeah. I mean, to be fair, I think you do often see lawyers also forgetting that when they go to the Court of Appeal and they are essentially asking the court to make another first instance decision without really couching it in the terms of an appeal. Not asking the court to apply a sort of an appellate perspective to it all, but just asking it to be reconsidered first instance. So perhaps unsurprising that the courts of appeal do end up uh, going a bit further than they perhaps should do.
Yeah. Yeah, absolutely, absolutely. Well, look, that was, except for the 2 that we're gonna talk about, what came out in September. So why don't we, seg right in to, a discussion about a Jamaican case, that actually has some much broader applications, we think.
That's right. So, yeah, the case that I chose to speak about today is the Cable and Wireless Jamaica and Eric Abraham's case, 2025 UKPC 44. As you say, it's a case coming out of Jamaica. And it's, I think, an important case, but arguably one that has been really criminally overlooked by commentators. And actually, in preparation for this podcast, I was having a look online, and I can't see any firm or chambers or anyone really who's given any commentary on this case. And I think that is short-sighted because it's actually a significant case on schemes of arrangement. And even though it ultimately arises from Jamaican law on schemes of arrangement, it has a much broader application because, as we'll see, the relevant statutory provision is almost identical to the English and Welsh statutory provision for sanctioning schemes of arrangement. And it's also interesting because um, it doesn't just restate what the law is, but it also addresses 2 of the often cited cases when it comes to sanctioning schemes of arrangement, which is the Re-Hellenic case the judgment of Templeman J, which essentially is overturned by
Mm.
this Privy Council judgment, and also the UDL Argos case of Lord Justice Millett in the Hong Kong Court of Final Appeal, and that case, which is often considered to be one of the key cases for the principles that we're going to come onto. That case was modified by the Privy Council, so I think it's an important case that deserves proper consideration and acknowledgement. So, before we get into the facts, let's just have a quick recap of what schemes of arrangement are for those of us or practitioners listening who don't regularly deal with these sort of matters. So, a scheme of arrangement is a legal process where a company can apply to a court for the sanction of a proposed compromise by the company with its shareholders or creditors in circumstances where not all shareholders agree. And so, the purpose is basically that if you aren't going to get unanimous consent, you go to court and you ask for the court to sanction the scheme and make it binding. And as the board said in this case, um, these provisions have proved to be a durable, flexible, and highly effective jurisdiction as regards arrangements with both members and creditors. So, in the Cable and Wireless Jamaica case, it was brought under Section 206 of the Jamaican Companies Act, and as I've already um, foreshadowed, um, English and Welsh practitioners will be familiar with the terms of that provision because it's basically identical to Section 206 and Section 425 of the UK Companies Act, 1948 and 1985, respectively. Um, and so, because a lot of the common law jurisprudence that relates to those English and Welsh provisions does have a wider application throughout the Commonwealth world, um, necessarily, really, this case will also have a wide application. Um, and so, what's required for a scheme of arrangement application? There's basically three steps. Firstly, company applies for the sanction of a scheme of arrangement to court, and the court at that point may order a meeting of the company's members or creditors or classes of members or creditors. Once the meeting's ordered, the second stage is that the meeting is held, and if a majority in number that represent at least three quarters or three fourths, as they use in the Jamaican provision, which I found slightly confusing when I read it. So, majority in number that represent at least three quarters in value of the members or creditors agree to the scheme of arrangement, then it's binding on the creditors or members if it is then sanctioned by the court. The really important point for the purposes of this case is that the meeting must be properly constituted. And what that means in this context is that if there are separate classes of members or creditors, there must be separate meetings. And as we'll see in a moment when I come on to the facts and the law, the key issue in the Cable and Wireless case was how do you determine whether there should be a separate class of members, and in that case, whether there should be a separate meeting. And so the third stage, if you get past the meeting, if you get the vote that you want, assuming you're the applicant, then you have a hearing back at the court when the court will determine whether to sanction the application. And at that stage, the members and creditors who oppose can come along and make their arguments about why the court shouldn't sanction. So that's an overview of what schemes of arrangement are and how the sanction application works. Let's turn to the brief facts. So, Cable and Wireless Jamaica was a partly owned indirect subsidiary of a larger company called Liberty Latin America. Liberty, as I'll call it, held 92.7% of the issued ordinary shares in Cable and Wireless through two subsidiaries. They were called CWC Cala and Kel Fenora. The remaining shares were held by about 20,000 minority shareholders. That included the respondent, Mr. Jason Abrahams. He was one of the minority shareholders. He had about 0.38% of the shareholding. Cable and Wireless, they wanted a scheme of arrangement sanctioned. The purpose of that scheme of arrangement was to effectively make Liberty the um, wholly owning parent. And what that would mean is that the minority shares, such as that of Mr. Abrahams, would be cancelled in consideration for the payment of one Jamaican dollar 45 per share by CWC Cala, which, as we've just seen, it is the majority shareholder um, of Cable and Wireless. And the plan was that once there has been that the shares have been purchased, they would be once they've been cancelled, they would then be reissued back to CWC Cala. So basically, CWC Cala is buying out the shares. And so that's an important point to bear in mind when we consider the law in a second. Basically, the effect of this scheme of arrangement was that CWC Cala, as the majority shareholder, but also as the shareholder that would essentially be buying out the shares, was both the purchaser and the seller, um, in terms of its status in the meeting. And this was an important point when it comes to things like rights and conflicts of interest. And so that was the plan. Cable and Wireless Jamaica applied to the Commercial Division of the Supreme Court of the Judicature of Jamaica, which is the first instance court in Jamaica, first instance court of unlimited jurisdiction. And it applied for the meeting, as we've seen. Court granted permission. Meeting took place. There was a single meeting, including all shareholders. So that was CWC Cala, Keller Fenora, and minority shareholders, including Mr. Abrahams. Perhaps unsurprisingly, the majority in number, representing 98.48%, voted in favour of the scheme of arrangement. Of the minority shareholders present, there's about 20% present. Almost all of them voted against it, and that included Mr. Abrahams. And so the matter then went back to the court, having the meeting having convened, and there was a sanction hearing before a judge called Bats J. And 3 points were taken by by Mr. Abrahams. The first was whether the minority shareholders, such as Mr. Abrahams, whose shares were to be cancelled under the scheme, were a separate class for the purpose of the scheme, such that there should have been a separate meeting for them. The second was whether the scheme involved a reduction in capital, and if so, whether the reduction was authorised. And the third was whether he should exercise his discretion to sanction. And I'm going to focus on the first of those three because it's the matter that has the broadest application. The basic position is that Bats J rejected the application for sanction because he found that there should have been a separate meeting because there were separate classes. Court of Appeal did the same, and it went up to the Privy Council. And so what did the Privy Council say? Well, the issue for the board was, what is the correct test for determining whether there are separate classes of members? And it came down really to two competing arguments. On the one hand, the appellant argued that what you need to look at is what are the rights of the shareholders prior to the scheme, the proposed scheme taking effect. And they were arguing, well, look, if you look at everyone's rights are exactly the same. And so therefore, applying the case law, because everyone's rights are the same, there's only one class, there only has to be one meeting. The competing view was really there were sort of two competing subviews. One was that you don't just look at the rights of the shareholders as they stood then, so prior to the implementation of the scheme. You also had to look at the rights as they would be affected by the scheme once it's implemented. And the second sort of argument was that you maybe you don't look at rights at all. You actually look at the interests of the members of the class. And so, what did the board say? Well, they were pretty dismissive of the appellant's argument, to be fair. It was the sort of case where they didn't need to hear from the the respondent on this issue, which is obviously never a good sign. It was also of such significance, I think, that they actually recorded in the judgment that they didn't hear from the respondent, which seems a little bit unnecessary.
Yeah, that seems cruel. That seems cruel.
No, it's like, we didn't need to hear from you because we think your argument's rubbish, and we're gonna tell everyone. But there you go. But anyway, so as you can guess, what they came down on was that a class for these purposes is constituted by reference to, and this is a quote, the similarity or dissimilarity of their rights against the company and the way in which those rights are affected by the scheme. So basically, it's the first of the 2 points that I made just now. You do look at the rights as it stands, so prior to the implementation. So uh, you look at that scenario, but you also look at what will the situation be after the scheme's implemented. So you look at how the scheme might remove or vary or confer different rights. And for that reason, as I'll come to in a second, it was obvious that in this case, um, the rights were different, because even though all the shareholders in Cable Wireless Jamaica had the same rights uh, prior to the scheme being implemented, it was obvious that they would have very different rights afterwards, because all of the minority shareholders um, effectively their shares were being cancelled, and they were being bought out, and all the majority shareholders were able to keep their shares, and there was, they were effectively unaffected by it. So there was obviously a difference in rights here. Um, in terms of how one approaches assessing similarity, perhaps in a case where it's less easy to define, the Privy Council said that the test is whether the rights are so dissimilar as to make it impossible for them to consult together with a view to their common interest. So that's how one approaches whether you have similar rights or not. You look at whether it is possible for consultation with a view to the common interest. Um, and dealing with the third point, which was whether you take interests into account, that was rejected out of hand. And this brings me to the 2 judgments that I referred to at the beginning of what I've been saying about this case. Firstly, in relation to the re-Hellenic judgment of Templeman J, the board basically said that it was wrong to look at categorizing classes of members by reference to interests. It simply isn't the right approach. What one needs to do is look at the rights. Secondly, what Millet LJ had done in the UDL Argos case was try to distinguish different sorts of interests in order really to support what Templeman J had said in Re Hellenic. And he had tried to distinguish between interests arising out of rights, and which would be relevant, and extraneous interests not arising out of rights, which wouldn't be relevant. But the board said that is unnecessary, it's confusing, and it's essentially modified that part of Millet LJ's judgment, or at least the effect of it, for future reference, whilst also endorsing much of what he said in that speech in the UDL case. So you look at rights, you don't look at interests, but as the board made clear at the end, the time that an interest would be assessed would be when you get back to the sanction application. And so in the round, for those reasons, the board ultimately did uphold the lower court's judgment and dismissed the appeal. There should have been there were separate classes, and so there should have been separate meetings. And so that is, I think, it's an interesting case. It's a case that, as I say, is interesting. Firstly, because it goes back into the law from various jurisdictions in relation to schemes of arrangements and sanctioning and constitution of classes. It reviews matters such as the Re-Hellenic judgment and really clarifies that once and for all, because there'd been a degree of uncertainty introduced in the UDL Argos case. But now that really has been closed down, and it modifies the principles that have been relied upon for many years from Mir LJ in the UDL Argos case. So, as I say, it's a significant case for anyone practicing in this area, and one that is arguably has been ignored in a way that is not justified.
Yeah, I mean, I certainly agree with that. Certainly agree with your last comment there. This is, as you say, that this is a case, a Privy Council case that deals head on with important English and Commonwealth authority dealing with schemes of arrangement. And as you say, either says that they were wrong or either puts a gloss on them. So this is a case that
Yeah,
if you're doing schemes, if you're doing scheme work, this case needs to be on your radar.
yeah. I mean, this I'd sort of venture to suggest that this is would be the case that one would now look at, because it goes into the leading cases from England, um, and it makes the clarifications that I've gone through, and so it needs to be on everyone's radar. And I think the fact is that because it is a Jamaican case, people will maybe assume that it is not going to be
Yeah.
applicable,
Yeah.
but I suppose that just reflects the importance of um, making sure that you keep up with what's going on at the Privy Council, but also recognizing that the Privy Council,
By reading
um,
JCPCWatch.com
well,
and
exactly, yeah,
listening to our podcast.
yeah. But yeah, so there you have it.
Yeah,
Yeah,
yeah.
it's an interesting one.
For someone who doesn't do a lot of scheme work, I've done some scheme work, but not a lot of it. I found the explanation of the assessment of how you should determine whether people should be in a class in this case. I found it actually quite easy to follow and
Yeah,
conceptualize. I thought it was in very user-friendly language, and I think the rubric that they set out about looking at the pre and post schemes rights, as
mhm,
opposed to trying to divine different people's commercial interests or
yeah,
other types of
absolutely.
interest, is much more user-friendly, and I think should be a lot easier, not only for practitioners and lawyers to use going forward, but courts to use when they're assessing whether the meetings are properly constituted, and even at the pre-meeting, at the convening hearing where you're determining to convene the meeting, where you're getting that initial order to convene the meeting. I think this should give a little bit more of an objective approach to that process, and maybe, and I don't know, maybe I'm going too far by saying this, but kind of back out some of the disputes at a sanction hearing about the constitution of classes. You'll always get people obviously to take a
Yeah,
run, but eh, when you stop looking at kind of people's subjective commercial interests and look at their actual
absolutely.
legal rights as against each other and as against the company, I think that tends to make things a little bit more objective.
Yeah. But, well, I mean, and then that's the thing. It is objective, and that's the whole beauty of it, I suppose. That one can easily ascertain the state of rights, that are in existence at the time of the meeting and will be after the scheme is implemented if it's sanctioned. And that's easily done, and everyone can understand it, and it doesn't depend on the assessment of interests and their degree and so on. So, yeah, I think that's right. I think it's a good point, and I imagine it will bring some
Yeah.
clarity.
I mean, the other thing that struck me when I was reading this judgment, Rupert, was why they used a scheme to do this
Yeah,
transaction. And as we know from our work in the Cayman Islands, if this was in Cayman, you would just do a merger. You'd do a
yeah,
statutory merger, where and under those provisions, as we talk about all the merger appraisal cases that come out of the Cayman Islands and end up at the Privy Council, you can do exactly this. You can take even a portion of the same class of shares and cancel them out and pay those people out. Yes, you have to pay them fair value, and yes, they have dissenting rights, and they can have a court determine what's fair value. But you're at least sure the transaction is going to go through on a
yeah,
certain date, and it will be done. And maybe you have to hold back some funds, and maybe you have a fight on your hands about what fair value is for your former shareholders, but you get the transaction done. Then I looked at the Jamaica Companies Act, which is pretty archaic.
Right. Yeah. I can.
It's pretty archaic. I mean, I think it even says a lot that what you said earlier that, Section 206 is what we were dealing with in the Jamaican Act, and it's the exact same as Section 206 of the UK Companies Act 1948. It's
Yeah.
not modern legislation, so it doesn't have the
Right.
same type of merger appraisal, merger and consolidation and appraisal rights that you find in some other jurisdictions. Although there are squeeze out provisions that could potentially have been used, and where I kind of ended up on it was someone made this decision, and anytime where I'm unsure of the specific why a specific form of a transaction was not apparent, I guess it's just driven by tax, which is oftentimes something you forget when you work in places like Cayman and BVI,
Yeah.
that there are still a lot of tax considerations that go into the form of these transactions in jurisdictions
Yeah.
that do have tax.
No.
Also interesting
Absolutely.
on the facts that there was like 20,000 minority shareholders in this company
Yeah.
holding a
Yeah.
tiny, tiny portion.
Yeah. Yeah. Um. Good stuff.
Well, I let's then let's move on and talk about uh, our next case, which is Krys against Farnum, and this is frankly the latest in the long-running Fairfield century.
It's given a lot of people work, that
It's given a
case.
lot of people work. A lot of people have eaten a lot of good meals on this case. This all arises out of Bernie Madoff, which, as you know, collapsed in the 2008 2009 financial crisis. Fairfield Century was an offshore feeder fund into Madoff. There's some we have to kind of go back to the beginning to explain how this case ended up at the Privy Council and why this fight has actually been going on between the liquidator, Kenneth Krys, and Farnum Place LLC, who is a claims trader effectively. So Fairfield Century, as I say, was a Madoff feeder fund. They had a claim in the Madoff estate in the United States that was admitted for $230 million, subject to making a $70 million payment into the Madoff estate. They agreed to sell their claim to Farnum Place for a little over 32 cents on the dollar. That was what Madoff claims were trading at in the market at the time that they made that deal. So at that rate, the overall benefit to the estate would be $4 million. So this was a sale that would have netted $4 million into the Fairfield Century estate for the benefit of the investors in Fairfield. The sale was conditional on approval of the BVI court and the US court by what was termed a final order of both of those courts. Importantly, for ultimately how this was resolved, the final order definition contemplated that there could be appeals or reviews going up the chain in either BVI or the United States. Now, here's where the bad timing really happens and where the dispute between these two parties picks up. 4 days after they agree to sale, the Madoff estate in the U.S. announces that they reached a settlement that would see $5 billion returned into that estate. Before that, everyone thought the estate was not going to have a lot of money, obviously, right? Claims were trading at 32 cents. The trading price of claims rose sharply. The Fairfield claim that they just agreed to sell for 32 cents on the dollar for a $4 million benefit into the estate would now be worth about $50 million more than what was agreed with Farnum Place. So a massive, massive swing 4 days later before there had been any actions to take to seek those court approvals. So at that point, the liquidator took the position that he wasn't bound to complete the sale, and so he just didn't apply for any of the court approvals on the sale agreement. Sale agreement says they're conditional on the court approvals. He says, "Well, I'm just simply not going to apply for them. I'm just not going to ask the court to approve these sales." Farnham itself forced the issue of BVI and brought the approval application to the BVI court. The BVI court approved the sale and then directed the liquidator to bring the necessary application to the U.S. bankruptcy court for the approval there, if approval was required. This led to a rash of litigation in the U.S. over this issue, because in the United States, the bankruptcy court first said that it had no role to play in approving the sale under the US bankruptcy code because It wasn't an asset within the jurisdiction of the United States. And the comity meant that it should just simply defer to the BVI court's approval. So the liquidator goes back to the BVI court, and as he's required to under the BVI legislation, whenever the liquidator wants to bring litigation, he has to go and get approval from his supervising court. So he goes back to the BVI court and he says, I want to appeal the US bankruptcy court's decision to the US District Court, which is the first level of appeal from the bankruptcy court in the US. The BVI court says no. Yeah, I'm not going to give you. I'm not going to let you appeal this. Just carry on with your transaction. I already said it's approved. The U.S. court says they're going to defer to me. Do it. Do your deal. The liquidator says, I don't like that. I'm going to go to the Court of Appeal. So he goes to the BVI Court of Appeal, which reverses the BVI court and says, yes, you can appeal to the district court in the U.S. The liquidator goes to the district court in the US, which affirms the bankruptcy court decision. So we're still at the stage where the sale transaction to Farnum is good. The liquidator goes back to the BVI court and he says, I want to appeal the district court to the Second Circuit Court of Appeals. Second Circuit sits in New York, is a very important court of appeals, as everybody who has ever interacted with US law issues knows. So he says, I want to appeal this to the Second Circuit. And the BVI court again says, no, would you stop this? There's too much delay going on. This agreement's been agreed for quite some time now. You're interfering with a deal that you made. You have to live with your deal. Go ahead and complete your deal. The liquidator again appeals to the BVI Court of Appeal and says, I want to appeal to the Second Circuit. Please let me do that. The Court of Appeal says, okay, we're going to hear your appeal. In the meantime, we recognize that your timeline is running out if you want to bring your Second Circuit appeal. So you can take steps necessary to preserve your appeal. It takes a very long time for the BVI court to do anything on this. So the liquidator has gotten approval from them to take steps to perfect his appeal and preserve his appeal. He does that. Other timelines keep coming up on the US appeal before the BVI Court of Appeal has actually dealt with this decision, has dealt with the issue, dealt with the appeal before it. So they keep giving the liquidator kind of interim authority to prosecute the appeal, to file things in the appeal, to file his position papers, and then finally to actually appear at the oral argument and make his appeal. So the Second Circuit appeal gets heard. Finally, the Second Circuit appeal gets heard. Finally, the Court of Appeal in the BVI hears the appeal against the initial rejection to bring that Second Circuit appeal. They hear that 2 months after the U.S. court is already hearing this appeal. It is from a procedural perspective and a
Yeah.
moving justice forward, speedy justice perspective, it's obscene. This is where we get really so these two appeals are heard in close proximity to each other. The Second Circuit brings down its judgment before the BVI court can deliver its judgment. So the Second Circuit gives down its judgment and it agrees with the liquidator. It says the U.S. court can review the sale under U.S. domestic law and wasn't required to defer to the BVI court. They send it back to the bankruptcy court. All of this time, we're still waiting to hear what the BVI Court of Appeal has to say about this. The liquidator sends the decision of the Second Circuit to the Court of Appeal before the Court of Appeal gives judgment and says, look, you know that appeal that you have to decide whether I have sanction to do? Well, it's been completed and I won. So maybe you should take that into account when you consider whether I should have been granted sanction for it. So we're still waiting on the BVI court to give judgment. They now have this appeal. They now have the result from the appeal that is actually the subject of the BVI court proceedings. It goes back to the U.S. Bankruptcy Court. The U.S. Bankruptcy Court takes up the issue again and refuses to approve the sale. The liquidator has won. Farnum tries to appeal it up the chain, but loses at all levels. The Supreme Court of the United States doesn't grant certiorari and effectively doesn't grant leave to appeal to the Supreme Court. So it is done. The dispute is actually done in the sense of there's not going to be a sale to Farnum at this point. At this point, the BVI Court of Appeal has yet to hand down its judgment. It's been years now. The whole issue has worked its way through the United States court system, has even gone up to the Supreme Court of the United States during this time, and has been thrown out. The BVI Court of Appeal, like 4 or 5 years later, finally hands down its judgment, in which it shockingly doesn't refer to the U.S. appeal. does not reference the decision of the Second Circuit, let alone anything that happened afterwards in the US bankruptcy court. Doesn't mention that success, and refuses to grant sanction. So they uphold the high court's sanction refusal. So the liquidator is now in a position where he's been refused sanction to bring an appeal that he's already brought and has won on. So there we go.
It's yeah, it's astonishing, really. I mean, I think the first thing that really does strike me is just how long the delay was. And I think it was nearly 8 years. I'm just trying to remind myself of the date of, I had the note on it earlier. The date, I think it was from 2014, um, when they reserved judgment, all the way until 2022 when they actually gave judgment.
It's
And
crazy, and there's no real explanation for the delay,
this
in
this is
any
the
of
thing,
these papers. Yeah.
and the board in their judgment say that it's remarkable, but I mean, I think that's, you
That's
know,
an understatement.
leave it alone.
Yeah,
I
yeah.
mean, it's not remarkable, it's insane. I mean,
It's
how
crazy, it's crazy. Yeah.
what I mean, I think it was you had, who was it was Obama was in power when they had the hearing. They had Trump. Trump won, and then Biden was in power by the time they delivered the judgment. I mean, what are they doing?
Yeah,
Like,
it's like,
honestly,
yeah, this is
it's
like the
I
7
don't
years
understand it,
war
and
could
I
have
think
been completed, in the amount of
well,
time it took them to
exactly.
hand down this judgment. Um,
So I don't I don't I mean, I had a brief look to see if we could find out some reason, but I mean, it is
no,
mind-boggling,
yeah,
frankly, and I'm surprised that more wasn't made out of it, or, you know, the Privy Council weren't more, disapproving of the delay, because the long and the short of it really is that it, in theory, completely invalidates a lot of the proceedings in the
yeah,
US. I
it
mean, obviously, the way that it ultimately worked out um, was such that that was remedied,
yeah,
but,
it's quite strange, and you're right, they don't even take that point at the Privy Council. What At the Privy Council, the liquidator argues that the successful appeal in the US was a material change in circumstance that the Court of Appeal should have taken into account, and the board deals with it in a sentence and basically says, of course it was."
yeah,
Of course it was a material change in circum they won the appeal that we're fighting about whether
yeah,
they should be able to bring.
yeah,
It's
yeah,
been
yeah.
done. So the
It was a
board,
pretty bold submission, I
yeah,
think, by the
it
respondent to say that that was not material,
yeah, it
when the very point, or the reason that the first instance judge in BVI um, had um, made the decision that he did, was because he didn't want to sanction indeterminate delay, and so
which,
that
look at your own
delay
court
actually
system here, mate.
yeah,
You're
exactly. Yeah, yeah. I think they should start at home with that
yeah,
one,
mhm. So, glasses
but
and
yeah, it
glass houses and rocks and such, but, the
no, it is astonishing.
Yeah, so the board said, "Look, obviously this was a material change in circumstances. The Court of Appeals should have taken into account, so we have to set aside the Court of Appeals judgment." The question then was, should they send it back to the Court of Appeal to look at this again, or should the board just deal with it? Um, Unsurprisingly, they say, "There's been a lot of delay here already, so we're just gonna do it." The board just, goes into it. They look back at the original high court decision. They find a lot of faults with the original reasons for refusing the sanction, basically saying that there was just a lot of misinterpretation of the actual obligations of the liquidator under the sale agreement, and the provisions of the sale agreement itself. A lot turns on kind of the final order definition that expressly contemplated that there could be appeals and reviews, of those decisions, and whether the liquidator had some kind of a positive obligation to fight for those approvals, or if the agreement, if they were just simply conditions precedent, and he was not actually obligated to try to satisfy those conditions precedent. So, they basically say that the high court misinterpreted, even on the first basis, even setting aside the whole issue that he was ultimately successful on the appeal that they're trying to bring, that in the first instance, the refusing sanction was wrong. So with the liquidator's position, clarified, and kind of very, very, nunc pro tunc is a massive overstatement of the situation. But he's now completely regularized the situation. The board kind of posits this as well in its judgment. Why were we here at all? Why were these parties in front of the Privy Council on this issue? Who cares if the BVI court granted or refused sanction for the liquidator to pursue an appeal that he won? Uh, what would Farnum, the respondent here, gain by having the board confirm the refusal of sanction when everything has been done, the sale agreement has fallen away, and there's no way for these guys to ever actually enforce that sale agreement? The sale agreement by its terms is done because the conditions precedent cannot be satisfied. The board wondered that. They questioned Farnham about it. They offered some explanations, which appeared to kind of go to claims they might want to bring against the liquidator if it had acted without authority. But interestingly, the board said that those factors were actually irrelevant to the sanction decision at all. So if the liquidator was trying to weasel or wriggle his way out of the sale transaction, by not seeking these approvals, and trying to challenge the approvals in the other courts, that actually doesn't that's not a relevant consideration, as to whether he should be granted sanction to pursue those, just because Farnham thinks it may have some claims against the liquidator. So I think this was an interesting decision in the insolvency context. It's a case that, the Fairfield Sentry case has generated lots of litigation on lots of different principles. It's not the first time that this liquidator, on Fairfield Sentry has been to the Privy Council on various matters. There's a lot of U.S. litigation that's created new case law. There's a lot of Commonwealth litigation that's created new case law on Fairfield Sentry. So this one might not have, given those very strange factual circumstances, big broader applications, but it's certainly, I think, a really interesting case. And I think just it is just one of those weird cases that's worth talking about, because of what it may say about, how slowly the wheels of justice often turn.
No, absolutely. Absolutely. Yeah.
Well, I don't think there's anything much more to say about that. So, Rupert, thanks for being here again and co-hosting
Thank you.
our little venture here. And thanks to everybody who's listening or watching. You can subscribe to JCPC Watch on YouTube, Apple Podcasts, or Spotify. You can visit jcpcwatch.com. And we'll be back soon with our next episode to talk about more Privy Council judgments and everything else that's going on at the board. Thanks a lot. See you
Cheers.
soon. Fairfield Sentry litigation.